Okay, so now we continue with the kinds of partnership. And in this fourth video, I will be integrating the kinds of partnership and the kinds of partners. So here, the kinds of partnership will depend on the criteria we are considering. Now, under the Civil Code, Article 1776 only enumerates four, but there are actually more. As you can see in the framework or the notes on law and partnership, which I uploaded, the notes of Attorney Laco. Under the notes of Attorney Laco, if I may just browse through it, he actually gives here. Yeah, he actually gives 12. Right. That's number 15. So let's start first now. Under Article 1776, as to its object, a partnership is either universal or particular. As regards the liability of the partners, a partnership may be general or limited. So as mentioned, we're looking into the criteria now to determine the kind of partnership. As to the object, as mentioned, there is universal and particular. So let's look into universal partnership first. A universal partnership now has two kinds pa. A universal partnership of all present property and a universal partnership of profits. This is stated in Article 1776. I forgot to include that. So I'll just read it out loud. Article 1776, as to its, under Article 1777, there you go. Under Article 1777, a universal partnership may refer to all the present property or to all the profits. So please add universal partnership as a kind under number 15 of the notes that we have uploaded. Now let's further look into the universal partnership of all present property first. This is covered by Article 1778 and 1779. Under Article 1778, a partnership of all present property is that in which the partners contribute all the property which actually belongs to them to a common fund with the intention of dividing the same among themselves, as well as all the profits which they may acquire therewith. 1779 further elaborates that in a universal partnership of all present property, the property which belonged to each of the partners at the time of the constitution of the partnership belongs to the common property of all the partners, as well as all the profits which they may acquire therewith. A stipulation for the common enjoyment of any other profits may also be made, but the property which the partners may acquire subsequently by inheritance, legacy, or donation cannot be included in such stipulation except the fruits thereof. So, note that here, it talks about all the present property of the partners which belongs to them at the time that they enter into the partnership contract. Now, before I move on to the example, generally, future property cannot be contributed because the essence of a contract of partnership is that the object is determinate, meaning at the point of entering into the contract, you already know what the object of the contract is. So, that is why here, it says that it has to be the property at the time of the constitution of the partnership. That's the general rule. However, because the parties can add any agreement into their partnership contract, they can actually make an express provision that pieces of property that they may subsequently acquire after executing the contract can be added into this universal partnership. So Article 1779, however, clarifies that what they cannot stipulate is to include property that they acquire by inheritance, legacy, or donation. So, if, for example, A, B, and C enter into a contract today and include their property and put in the put in the partnership contract that they will also include property they will get later on. Say A purchases a piece of land next week, that can be included into the partnership contract because A subsequently acquired the property by buying it, not by inheritance, legacy, or donation. However, okay, moving on. When it comes to property that the partners may acquire by inheritance, legacy, or donation later on, while the same cannot be included in the partnership of all present property, the income from that inheritance, legacy, or donation can be included. Alright, so I'll go now to my example. This is actually the example of Attorney Soriano in his book. A and B formed a universal partnership of all present property. At the time of the establishment of the partnership, A owned a fleet of taxis which he had purchased and an agricultural lot which he had inherited. B, on the other hand, owned an apartment which he had earlier acquired by exchange and shares of stocks which were donated to him. The partners agreed that the property acquired by each partner after the formation of the partnership shall belong to the partnership. During the first year of operations, the following transactions took place. Okay, now before I continue with the transactions that took place during the first year of operations, please note the following items stated in the example. First, A owned two pieces of property, which is the fleet of taxis and the agricultural lot which he had inherited. B, also having two pieces of property, had an apartment and shares of stock which were donated. Okay. Now, if you look at Article 1779, there, it said here that property which will be included are those that belong to the parties at the time of the constitution of the partnership. So, please do not be confused. Although the agricultural lot was inherited by A and the shares of stock were donated to B, these will be included in the universal partnership of all present property because they already had this at the time that they were to execute the partnership contract. Article 1779, which says that you cannot include property acquired by inheritance, legacy, or donation, only refers to property that they acquire after they execute the partnership contract. Okay. So let's continue. During the first year of operations, the following transactions took place. Fair revenues of 200,000 were realized from the operation of the fleet of taxis. B, crops amounting to 100,000 were gathered from the agricultural lot. C, rentals of 150,000 were collected from the apartment. D, dividends of 50,000 were received from the shares of stock. E, a coconut plantation was purchased by A from his own funds. F, coconuts worth 80,000 were gathered from the coconut plantation. G, a fish pond was received by B by way of donation from a rich uncle. And H, fish valued at 70,000 were harvested from the fish pond. Okay, so with the transactions that transpired after the operations, during the existence of the operation, A acquired another property, a coconut plantation, which he purchased from his own funds. And B acquired a fish pond by way of donation. So following 1779, this fish pond will not be included, but the coconut plantation will be because A purchased it anyway. So it was not by inheritance, legacy, or donation. Okay, so with that, here's the answer. Under the universal partnership of all present property, um, these belong to the partnership. The fleet of taxis, the agricultural lot, the apartment, the shares of stock, which I've already explained that even if the shares of stock and the agricultural lot were acquired by donation and inheritance, they will be included because A and B already had these at the time that they executed the partnership contract. Also included are the income resulting from these pieces of property, which is the uh, fair revenue, the crops, the rent, the dividends, and the coconut plantation, as I just mentioned, is included because A purchased it anyway, and the coconuts thereof. The coconuts harvested from the plantation. Now, as for the fish pond, as mentioned already, it will not be included. But the yeah, I just sorry. But the fish that were harvested from the fish pond are included, as expressly stipulated in Article 1779. The fruits can be included. Okay. Now, on to the second type of universal partnership. The universal partnership of profits is provided under Article 1780. A universal partnership of profits comprises all that the partners may acquire by their industry or work during the existence of the partnership. So, movable or immovable property which each of the partners may possess at the time of the celebration of the contract shall continue to pertain exclusively to each. Only the usufruct passing to the partnership. So, what is usufruct? Usufruct is the right to enjoy the property of another with the obligation of preserving its form and substance. So, usufruct is actually just a legal term for use. There's just a qualifier that when you use it, you have to preserve its form and substance. So, I'll just write that down here that this is actually covered by Article 562 of the Civil Code. For those who might want to write that down there. So, if a partner contributed money, then how can that be used? You cannot return the same banknote with the same serial number. If a partner contributed money, then what will be returned to the partner will be an amount equivalent to what he or she gave. And it will be as a loan to the partnership. So, if ever, say, A contributes 1 million, because and they form a universal partnership of profits, whatever income that will result from that 1 million investment of A will be divided. But when the partnership will be dissolved and liquidated, the partnership will have to return the 1 million investment of A. And that will be like a loan to the partnership upon dissolution. Okay. So let me just clarify. That does not mean that A is a creditor. The point of saying that it is a loan is if and when the partnership is dissolved. That is the time that the partnership will return the money to A and treat it like a loan. Okay. All fruits of the property subsequently acquired by the parties do not belong to the partnership but may be included by express stipulation. Okay. So, the reason for this qualification, and please take note of this, is because Article 1780 states that the universal partnership of profits comprises what they may acquire by their industry or work. So when it comes to property, the income from their property that they subsequently acquired is not automatically included in this universal partnership of profits. But they may include that if they put it in the contract. Okay, so let's look at this from the example given earlier, but add that A received a 200,000 salary from teaching. And I forgot to write it down, I'm sorry. Let's also add that B won 1 million from the lotto. There. So, given the same example earlier as the one earlier, with the addition of a 200,000 salary of A from teaching and 1 million pesos won by B in the lotto draw, the following now belong to the partnership: the fair revenue, the crops, the rent, the dividends, the 200,000 salary here, evidenced by the paycheck, the coconut, and the fish harvested. However, as mentioned earlier, here, let me just put that here, because it comprises all that the partners may acquire only by their industry or work, the lotto winnings will not be included. Okay, now here's a question. What if the articles of partnership did not specify if it's a universal partnership of all present property or profits? Article 71 states that if it is not specified, it will only constitute a universal partnership of profits. Why? Because the partners make a donation in a universal partnership since they're giving everything. So, if you remember your interpretation of contracts under Article 1378 of the Civil Code, when it is impossible to settle doubts, then, and it refers to a gratuitous contract, it will be interpreted where there will be the least transmission of rights and interests. So, because a universal partnership of profits is less onerous or has the less transmission of rights than a universal partnership of all present property, in case of doubt, it will be assumed that the partners refer to creating a universal partnership of profits. So, since we are talking about the universal partnerships, whether it refers to all present property or income, uh, if you remember Article 1782, persons who are prohibited from giving each other any donation or advantage cannot enter into a universal partnership. This would refer to um, donations between spouses under the family code. If you recall in a previous video, what people cannot do directly, they cannot do indirectly. So if spouses cannot make donations to each other, they cannot enter into a universal partnership universal partnership, whether it's present property or profits. Okay, so let me just illustrate it with a Supreme Court case. In a 1969 case called Commissioner of Internal Revenue versus Sutter, if I'm pronouncing that correctly, there were three people involved here. Is it Sutter or Suter? Anyway, Julia Spirig and Gustav Carlson. So, William and Julia, William, Julia, and Gustav. Now, Julia Spirig and Gustav Carlson were limited partners. These three contributed 20,000, 18,000, and 2,000 pesos as investment for the importation, marketing, and distribution of phonographs, which are not used anymore. Honestly, I've not even seen one. Radios, TV sets, amusement machines, and the parts and accessories for these appliances. Now, the following year, or in 1948, the year after they created the partnership, William Suter and Julia Spirig got married. That same year, Gustav Carlson sold his share, so the 2,000 that he invested plus his profit, he sold it to the spouses. So, after that marriage, Spirig and Suter filed their income tax returns as a corporation, and the Commissioner of Internal Revenue just accepted it. They did not object, meaning the commissioner did not object to the ITR of the partnership until 1959, so almost 10 years later. They were assessed deficiency taxes because um, partner because the commissioner said that they should consolidate their income from the partnership and their personal income into one ITR and not treat it separately. Now, the Court of Tax Appeals reversed the assessment. The Commissioner of Internal Revenue, however, insisted that the income from the partnership should be reported as the individual income of the spouses. The CIR said, the commissioner said that when William Suter and Julia Spirig got married, the partnership was effectively dissolved. The Supreme Court ruled in favor of the spouses, meaning in favor of the validity of the partnership. The Supreme Court said their contributions were fixed sums because they gave 20,000 and 18,000 plus Gustav Carlsson's 2,000. Therefore, this partnership was only a limited partnership. So the Supreme Court, as I mentioned, sustained the existence of a partnership. If this case were a universal partnership of all present property or all profits, the ruling of the Supreme Court would have been different. The Supreme Court would have sided with the commissioner and would have said that William Suter and Julia Spirig's marriage would have effectively dissolved the partnership because under Article 1782, they cannot enter into a universal partnership. Okay. So, just to add, for those who want to look for your information only, I don't think you need to memorize this. If you look at Article 84 and Article 87 of the Civil Code, it states that what they can of the Family Code, Article 84 and Article 87 of the Family Code, if the future spouses agree upon a regime under an absolute community of property, they cannot donate to each other in their marriage settlements more than 1/5 of their present property. Any excess shall be considered void. And under Article 87, every donation or grant of gratuitous advantage, direct or indirect, between the spouses during the marriage shall be void, except moderate gifts which the spouses may give each other on the occasion of any family rejoicing. So, Articles 84 and 87 of the Family Code are in line with Article 1782 of the Civil Code. Okay. Just to add, Article 739 of the Civil Code is also in line with this when it enumerated the list of void donations. So, this one does not talk about, Article 1739 does not talk about donations between spouses. It says here, the following donations shall be void. 1. Those made between persons who are guilty of adultery or concubinage at the time of the donation. The Supreme Court added that no conviction is needed. Number 2, those made between persons found guilty of the same criminal offense in consideration thereof. And number 3, those made by a public officer or his wife, descendants, and ascendants by reason of his office. There. So, the last paragraph, Article 739, states that in cases referred to in number 1, when it comes to donation between persons who are guilty of adultery or concubinage, the action for declaration of nullity may be brought by the spouse of the donor or donee, and the guilt may be proved by preponderance of evidence in the same action. So that's why the Supreme Court said you don't need a criminal conviction. It can be that the guilt of the donor or the donee may be proved in the action for the declaration of nullity of marriage. Alright, so the second type of partnership, when you consider the object or the subject matter, is the partnership for a particular undertaking. So this is the opposite of a partnership of universal partnership, So this one contemplates a partnership organized for a certain undertaking which, when attained, will cause the termination of the partnership. So under Article 1783, a particular partnership has for its object determinate things, their use or fruits, or a specific undertaking, or the exercise of a profession or vocation. So, in a partnership for a particular undertaking, it need not be of a continuing nature. So you might want to look into 1767 and here 1783 as already mentioned. It can be for a particular piece of work, a specific undertaking, or a single transaction. Okay. Now as to the partner's liability, there are two, a general partnership and a limited partnership, covered by Article 1816 for general partnerships and Article 1843 for limited partnerships. So, under Article 1816, all partners, including industrial ones, shall be liable pro rata with all their property, and after all the partnership assets have been exhausted, for the contracts which may be entered into in the name and for the account of the partnership. Okay. And so the reason why a general partnership is defined under Article 1816 because the partners will be liable pro rata or in proportion to their personal property, but only after all the partnership assets have been exhausted and it's still deficient there. So this refers to personal property. Okay. Now for limited partnership, covered by 1843, it is when one or more are general partners and one or more are limited partners. So limited partners shall not be bound by the obligations of the partnership. Meaning, for a limited partner, the limited partner's obligation is only up to the extent of his or her contribution. Okay, so just to clarify, pro rata means in proportion. When you say subsidiary liability, you refer to a partner being liable only after the creditor cannot run after the partnership. That's when the partnership assets have already been exhausted. And solidary liability, just for your information, means that each partner is equally liable for the entire amount. I just want to put that out there because you might be hearing these legal terms later on, whether here in our course or in another legal course, law course. Yeah. So, because of this general partnership, I would just like to reiterate from my previous video, this is why the acceptance of a new partner must be with the consent of all partners, because this new partner might be disadvantageous to the partnership. And if it happens, the old partners will still be liable for whatever the new partner does up to the extent of their personal property if the partnership assets have already been exhausted. Okay. Now, as to the representation of to others, there is an ordinary or real partnership, meaning one that actually exists, and it exists among the partners and it exists as to third persons, and a partnership by estopel, or which we also call a nominal partnership. Partnership by estopel or nominal. So a partnership by estopel is covered by Article 1825. It's actually a very long provision which we will thoroughly discuss in a later video. But I just want to explain that a partnership by estopel are those where they are partners only to those whom they represent themselves as partners. So we're talking about their conduct. If A and B act as if they are partners even though they're really not, then say X, who loaned them money thinking that there was a partnership there between A and B, A and B will be partners by estopel in favor of X. Meaning, even if X gave the money only to B, but A and B acted as if they are partners. Meaning, B went to X, asked for money, pretended that they were partners, and A said that, yeah, we are, but they're really not because they just took the money. Then X, thinking that there was a partnership, can now run after A and B. A now cannot say, oh, you cannot ask me to pay because there's no real partnership. That's the point of a partnership by estopel. So, in the book of Soriano, the book of Soriano actually interprets Article 1825 so that it's easier rather than just looking at the legal provision, contemplates 3 types of partnership by estopel. There. Number 1, when a person represents himself as a partner in an existing partnership. So A, if all the partners consent to such misrepresentation, let me just highlight that all, a partnership by estopel is created between the actual partners and the person who made the misrepresentation. So here, a partnership liability results because all the partners agreed or they consented to the misrepresentation. So the assets of the partnership shall be used to pay the liability. Sorry, please disregard this period. Okay, so, and if the partnership assets are insufficient, both the actual partners and the person who made the misrepresentation will be liable with their separate property. Okay, however, in a second scenario, if not all the partners consented to the misrepresentation, then there's no partnership liability. Here, a partnership by estopel is created only among the actual partners who consented and the person who made the misrepresentation. They will each be liable jointly or pro rata in proportion to their separate property. Okay, and the third situation contemplated by a partnership by estopel is when a person represents himself as a partner in a non-existing partnership. Where I mentioned a while ago, A and B pretended to be partners to X so they can loan money, pretending that they will use the money they'll get from X to, say, run a business. Here, no partnership liability arises, obviously, because there is no partnership to speak of. But the person or the people who made the misrepresentation and all persons who consented are liable also jointly or pro rata. So, there. I'll give another example, the one stated by Soriano. If A, B, and C are partners in durable enterprises and they want to purchase materials on credit from X, but X does not know any of them, so he doesn't trust or he might not give A, B, and C credit. But X knows D and trusts him. Now, if A, B, and C go to if A, B, and C go to D and ask D, hey D, can you please help us get credit from X for 90,000 so we can buy materials? And D goes to X saying, oh, I'm partners with A, B, and C, can I buy on credit? And X extends credit. There is a partnership by estopel because in reality, the partnership is only between A, B, and C. So, assuming, for example, they were able to purchase on credit materials worth 90,000 and they only have assets of 60,000. X may now go after the 30,000 difference from A, B, C, and D. Yan. But if, for example, only A and B permitted D to represent himself as a partner and C did not consent or does not know at all, in that case, X can only claim the difference of 30,000. X can claim the 90,000 from A, B, and D. X cannot now run after the 60,000 of the partnership because C did not consent or she does not know that D misrepresented himself. Okay. Now, if as to the legality of the existence, there is a de jure partnership, or a partnership that complies with all the legal requirements, and on the other end of the spectrum, a de facto partnership, meaning a partnership that exists in fact but not in law because they failed to comply with all the legal requirements. So, the legal requirements that we are talking about are those under Article 1773 on immovable partnerships. So, as to the duration, there is a partnership with a fixed term and a partnership at will, and they are both covered by Article 1785. So, under Article 1785, if you read it, when a partnership for a fixed term or a particular undertaking is continued after the termination of such term or particular undertaking without any express agreement, the rights and duties of the partners remain the same as they were at such termination, so far as consistent with the partnership at will. A continuation of the business by the partners or such of them as habitually acted therein during the term, without any settlement or liquidation of the partnership affairs, is prima facie evidence of a continuation of the partnership. Okay, what does this mean? This means that a partnership with a fixed term is not set in stone. Meaning, once the term has already expired and the partners continue the partnership, it is now converted into a partnership at will. Now, please note that the terms under the partnership with a fixed term will be the same terms in the partnership at will only if there is no express agreement, meaning the parties did not create an agreement to change the terms. Yeah. So it's very easy to understand. So let me just add, aside from Article 1785, that in a partnership at will, where there is no period fixed by the parties, it is not formed for a particular undertaking or venture. Because if the partnership was formed for a particular undertaking or venture, then it is one with a fixed term. The term being the same duration as how long it would take for that undertaking or venture to be accomplished. So in a partnership at will, because there's no term, it can be terminated anytime by mutual agreement or by the will of any partner. Okay. Now next, as to the purpose, which is both defined and stated in Article 1767, there is a commercial partnership and a general professional partnership. So, why do you need to distinguish? Mainly because of taxes. Under the National Internal Revenue Code, which is now amended by the Train Law, a commercial partnership is a taxable corporation. So, the taxes of a commercial partnership are separate from the taxes of the individual partners. However, in a general professional partnership, the taxes in the general partnership will be part of and will be reported by the partners in their individual capacities. So it is the practitioner or the professional who is liable to pay for the income tax in their separate income tax returns. So say if attorneys A, B, and C enter into a firm, they create a firm and they are partners, the income from that firm will be divided between attorney A, attorney B, and attorney C, and they will each report their share in the income as part of their personal income tax. Okay, now, for those reading De Leon's book, he added another requirement as to publicity. There is a secret partnership and an open notorious partnership. Now, a secret partnership exists where the existence of certain persons is not made known to the public. Okay. So, caveat. it is not the same as a secret association, which we previously discussed in the earlier video as contemplated under 1775. Because under 1775 or a secret association, what is kept secret is the articles of partnership. Here, in a secret partnership, what is kept secret is the existence of a particular partner. So this is really a secret partner more than a secret partnership. You just might be confused. And that's also probably one of the reasons why Attorney Laco did not include that in a kind of partnership in the notes which I have uploaded. So, as to the kinds of partners, let's continue in the same video as I mentioned earlier. The types of partners are classified according to the partner's interests in the business, their obligations to the partnership, or their obligations to third persons. So I already included that here. There are, 21, but I have put some asterisks on some, and I'll explain later. So let's go through it first. Now, number 1, a general partner is one who is liable for partnership debts to the extent of his separate property after all the assets of the partnership have been exhausted. So, a general partner is present in every type of partnership. We have already mentioned this under Articles 1843 and 1816. We will discuss this later on when we go to the liabilities, rights, and obligations of the partners. So, I'll just write it down for reference. Okay. Number 2, a limited partner is the opposite of a general partner. He or she is one who is liable for the partnership debts only to the extent of the limited partner's capital contribution. That is why a limited partner cannot contribute industry. So he is also known as a special partner. I'll just write that here, special. Now, there's a hybrid type, a general limited partner. This partner, general limited partner, is one who has all the rights and powers and is subject to all the restrictions of a general partner, meaning a general limited partner will be liable up to the extent of his or her personal property. But the beauty about being a hybrid type, a general limited, is that this partner will only have limited liability as against the other members of the partnership. So, for example, in this case, the general limited partner is liable pro rata to partnership creditors as if he were a general partner, but that general limited partner can demand reimbursement of the amount he paid from his co-partners. So, for example, in a case where A, B, and C entered into a partnership where A is a limited partner, B is a general partner, and C is a general limited partner, and the partnership assets falls short of its liabilities by 30,000, the creditors can collect the balance of 30,000 from the separate assets of B as the general partner and C as the general limited partner. But C can demand from B the 15,000 that C will pay because in truth, C is a limited partner. C being the general limited now. There. Okay. I hope you got that. If not, please do message me later on. Okay, number 4. Capitalist partner. A capitalist partner is one who contributes money or property to the common fund. An industrial partner is one who contributes his or her services or industry to the partnership. And there is a hybrid again, a capitalist industrial partner, meaning one who contributes not only money or property, but also their industry. Now, there's also a managing partner. By the term itself, is the one who manages the affairs of the partnership. Sometimes, the managing partner is called the real partner. Just want to inform you in case you come across that term in your textbook of your choice. Yeah. And the managing partner is appointed in the articles of partnership or is appointed after the partnership is created. Okay. And a liquidating partner is the one who takes charge of winding up the affairs of the partnership after it is dissolved, and we will discuss this later on when we go to dissolution and liquidation of partnership. A nominal partner or partner by estoppel is not a partner but becomes liable to third persons who believe that this nominal partner is a real partner. Is a true partner. Yeah. So sometimes you will see some books call this nominal partners a partner by implication. Okay, please pardon my handwriting again. Okay. An ostensible partner is one who is active in the management of partnership business and known to the public as a partner. So he is a known active partner. So this is usually when someone allows his or her name to be included in the firm name. So regardless if the ostensible partner has an actual interest of the firm, if this ostensible partner is not really a partner but acts as if he is one and actively manages, he will be a partner by the doctrine of estoppel. Okay. Now, what's the opposite of an ostensible partner? A secret partner. One whose membership is not known to the public. So, what is the purpose of a secret partner? A secret partner wants to participate in the profits and losses and even has a voice in the management, but it's just that the public does not know that he or she is a partner. Okay. Now, a silent partner is one who has no voice in the management. So this one, this one manages, and this one does not manage. All right. So a silent partner has no voice in the management of the business, so he may be a partner. So if he withdraws from the partnership, he must give notice. Because a silent partner is still a known partner. Take note, a secret partner is not known to the public, but a silent partner is known to the public. It's just that the silent partner does not actively manage. So if this silent partner withdraws from the partnership, notice must be given to those who do business with the partnership. Okay. A dormant partner is one who does not participate in the management and is not known. So a dormant is actually, if you put it into a mathematical equation, a dormant partner is a secret and a silent partner. There. Dormant partner is also called a sleeping partner. So a dormant partner may retire without notice to the parties, to third persons, because his interest in joining would only be in the sharing of the profits. Yeah. So a quasi-partner is one who is no longer a part of the business but has left his capital in the business as a loan. So he receives interest on such as long as the loan is not paid off. So a quasi-partner is someone who leaves the partnership and then becomes a creditor because the property he or she contributed remained with the partnership. Okay. So a retiring partner is one who decides to leave after reaching the age of retirement. So the retiring partner may or may not take the property contributed with him or her after retiring. The original partner, which De Leon classifies, and it's not included in the notes, that's why there's an asterisk, is one who is a member from the time of the partnership's organization. For accountants and lawyers and other professionals, they're usually called the founding partner. And opposite an original partner is a newly admitted partner. If you look at Article 1826, a person admitted as a partner into an existing partnership, meaning admitted after it was created, is liable for all the obligations of the partnership arising before his admission, as though he had been a partner, except that this newly admitted partner's liability shall be only out of partnership property, unless there is a stipulation to the contrary. Meaning, for example, A and B are founding partners. After they created the partnership, a newly admitted partner, C, was added. So, if the partnership already had outstanding obligation, meaning its debt was more than its assets by, say, 30,000, C, the newly admitted partner, his liability will only be to the extent of how much he or she contributed. So, for example, at the end of the partnership, it was discovered that there was 30,000 that the partnership owed even before he entered. Then, to the extent of 30,000, and CC only contributed 15,000, then you can only run after he is only liable to the extent of 15,000 in relation to that debt, because that debt was incurred before he was admitted. So be careful, because once C is admitted, any liability that the partnership may have from the time he was admitted and thereafter, he will be liable up to the extent of his personal property. This is assuming that the newly admitted partner is a general partner also. Okay, so next. A substituted limited partner is one who is admitted to all the rights of a limited partner who has died or assigned his interest in a partnership. Okay, so as for these last three, there are asterisks because these were added classifications by De Leon. A continuing partner is one who continues the partnership after it has been dissolved. Okay, so 20 is a surviving partner or one who remains after a partnership is resolved by the death. Kaya nga surviving. So technically, a surviving partner is a continuing partner. And 21, a subpartner. One who, not being a member of the partnership, contracts with a partner with reference to the partner's share in the partnership. So this is when, for example, A and B enter into a partnership and A assigns his rights to C. C will not be a, say this is A, this is B, they enter into a partnership and A only assigns his share to C. C is only a sub-partner. Because technically, actually this is a misnomer because C is not a partner. Remember, in order for one to become a partner, there must be an agreement between all partners. In this case, B should have consented to the admission of C. If B does not know yet or does not consent, then C is just an assignee of A. This is probably why the notes also do not include subpartner as a kind, because it's a misnomer. I just want you to know, because for those who are reading De Leon's book, this is actually an added classification. Okay, so that ends our discussion for the first week on the law on partnership. Now, the next video will be about the topics under week 2, more particularly the operation of the partnership, management of the partnership, the rights and obligations of the partners, and the rights and obligations of the partnerships.